start our recording. So again, very briefly, Diane Michael, Southern States Management Group. It's October 27th. We appreciate you being here for our Build Your Bench and Community Association elections. Thank you for allowing me the time to go over all of that. And without further ado, Troy Railsback with Southern States Management Group. I will pass it over to you, Troy. Take it away.
Thank you, Diane, and Wright and Casey for participating, and everyone who is on the outreach program Zoom call today. Again, as Diane mentioned, my name is Troy Railsback, Southern States Management Group. Been there for since 2007, so got about 12 years under my belt, and the management company itself has been around for 31 now. We just passed our 30-year anniversary last year. So we are going to endeavor sharing some of our experiences and trials and tribulations along the way, very briefly, as far as board members and how to get elected to the board. And I'll leave all of the technicalities to the Wright Casey folks. So I come from a sports background, played basketball, so I relate the board or the team concept when I think of board members and recruiting board members. And I think of, kind of like a tryout, if you will. And then, if you've never played basketball before or you've never been a board member before, you kind of need to know what the roles are and what your responsibilities are, and you basically how to play the game. And the good news is we're in a small election year this year, and we've all been privy to, candidate opportunities for candidates to cheerlead for themselves, if you will, and quote unquote debate on subjects. So the board HOA condo concept isn't completely parallel to say the presidential election. But there's a lot of similarities. There's an opportunity for someone to become a candidate. And so one of the first things I want to talk about is, how do you identify a potential candidate? How do you figure that out? So the statute is pretty clear that you have to do a call for candidates, and in some instances you have to have open a call for a candidate at the actual annual meeting. But we're going to just kind of stick with the current time best practices, which is, in the statute's pretty much aligned there unless the documents are super old, is in advance of a board meeting, in accordance with the statute timing, you need to send in first notice that you're having an annual meeting and an election, and you call for candidates. And they have a candidate information sheet that they should fill out. And you should have one that you've adopted as a board member. The statute gives a pretty good template. And so you should have that, and you should consistently use that every year. And so that's what you have to do. You have to send a first notice, you have to call for candidates, and you have to give a time frame for them to let you know they want to run for the board. And the other way to endeavor doing this is as a manager of an association or as a board member, you are going to have conversations each and every day throughout the year that someone may either say, how do I get more involved? Or I want to change this, or I'm really upset. You should, in a non-adversarial way, invite them to participate. And that's how you identify potential board members and engage them at, say, a committee level, or first things is to send them to, kind of the website or the meeting notice that, hey, we have meetings once a month. They're at this time, they're at this location, and invite them to participate as an audience member or a member of the association at the board meeting, and build upon that. So one way to engage members is to, number one, be transparent about when you have meetings. Invite the membership to participate on a committee, and we found that, whether it's an art committee member or a fine committee member or someone who regularly attends the meetings, those are members of the associations that will make really good board members down the road. And so that's, you have them on the bench, if you will. And so we always endeavor from one year to the next, or from one term to the next, identify board members who are ready to cycle out or you don't have the time anymore. It's to kind of know that in advance, and don't just identify that you're going to have a vacant seat, just because one of the board members just doesn't turn in their candidate sheet. I think it should be an open dialogue. You can't call for candidates all along the year. You have to do that as part of your meeting and follow the formal balloting process if you do an all call for candidates. So be careful of that. But you should identify that, as a committee opening happens or another volunteer opening happens, identify those individuals who want to participate, who you hope their thought process is aligned with the best interest of the association and not necessarily just a personal agenda. And you should cultivate that all along the way. And when you do your call for candidates, hopefully those individuals will turn in their candidate sheets along with anyone else who does. And as you get to know those candidates, they will, and the balloting process goes through, they will hopefully rise to the top and get selected to participate as a board member. The one of the things that we've done, I've been lucky enough to have a very large association of 1,900 plus homes, and they have identified a point in time between the call of the candidates and the election to do what they call candidates night. So they've put on almost like a town hall informative type style meeting. It's not a board meeting. We're not doing a quorum of the board. We're basically setting a night, putting in advance. We've incorporated to our annual meeting notice in our election process that if we have more candidates than seats available, we're going to have a candidates night and you're invited, and we're going to let you know about that. It's going to look a little different this year. I don't think we're going to be in a room with them speaking live, but we're going to make it happen. We're probably going to either have a 1 or 2 page document that we post on the website on the night we would have the candidates night, or maybe even videotape the candidates. So we haven't figured out exactly how we're going to do it, but that's part of our, over the last 8-9 years, part of our election process. The membership, they relish it, they look forward to it, and we time it so that the ballots don't go out until after we have that candidates night. Well, what we're trying to do is allow the membership who wants to vote for any of the individuals that are going to be on the ballot, to allow them the opportunity to get to know them first. And so we want to be able to look back when challenged to say, well, I didn't know anything about this person, or you didn't give me an opportunity to, let people know who I am. It is their responsibility. It's incumbent on them to kind of rally their fellow membership to vote for them. But the boards feels it's important to make, to give them that platform and have that opportunity above and beyond what they want to do individually. And then, it is an opportunity that we, identify to just those who are participating, to let them know what the board members are doing and how they're participating. Or have regular quorum established board meetings and regular schedule. And so we just educate the membership all along the way. So I think it is very important for the board to identify regular meeting schedules, transparent information, whether it's a newsletter or e-blast, and try to do it very consistently and not erratically. So if they miss something or one thing, they're totally in the dark. We're trying to be, very transparent, have it in all on the website and owner portal, in some type of a newsletter or print that goes out to the membership on a regular frequency. And we've timed all those things so they work around the major inflection points like the annual meeting and the election. All right, I'm going to talk for 1 minute here, 2 minutes here about the kind of the board member and the election process, and then I'm going to turn it over to Barbara. So get ready, Barbara. So we want the membership and the board to be familiar with the process. If a board member finds himself on the board because they got appointed because maybe a previous board member moved out of the neighborhood, we want to educate them. We want to get them involved in the process, have them understand it and be comfortable with it. And along the way, we're going to identify opportunities for the membership to hear that same information. So we would, do certain things at meetings and have discussions and, elect officers and do all of those things in an open, transparent format at a duly noticed board meeting, and not say, oh, well, we just kind of did this because of this circumstance. No, we're going to notice the meeting in advance and be very fastidious about making what is going to happen and transpire at that board meeting on that agenda. Put that out there, blast it to everyone, post it, or however your meeting notice it comes out, and make sure everyone's involved in that process that wants to be, and then make sure it's reflected in the minutes. And we are constantly in the education forums and at our board meetings trying to make sure it's very clear that the board members are elected to run the business. The association is a business. It should operate like a business, and they've been elected to do such. And so we want to make sure the membership understands how that process works, and again, get them engaged if they want to participate. And so if you're doing an election process, I'm just going to talk real quick. So we've sent both of our notices. We've did our call for candidates. We have our ballot out there. And so if you're a self-managed community, or you have maybe your question how your process is going, make sure it's in accordance with statute. Really, it would encourage you to use a dual envelope system with a ballot that doesn't have a name or anything on it. So you have an internal, you have a ballot, you have an internal ballot envelope that just says ballot on it. Now you have an external envelope that is registered with the person's signature, property address, and or account number, and make sure that you can verify that. And so you have an outer envelope, an inner envelope, and then the ballot inside of that. And so as you get to your annual meeting and you've collected these ballots, nothing should get opened in advance of the meeting. So I want to, sometimes there's a misconception that the management company or whoever's collecting the ballots, or the secretary or something, they should start opening them right away. That there's exposure there to, well, who registered, which one, and you want to do that all at the annual meeting. We've found that it's in the best interest of the association to have a non-candidate member of the association who's participating at the board meeting, a group of them, 4, 5, 6 of them, open the ballots on behalf of the management company and the board. And so now the membership participates in the process. The integrity of a registered ballot, because this is a current owner, they don't have a delinquent balance, and you've gone through all those protocols, and they're going to separate the outer envelope with the inner ballot envelope. Now you don't know where that inner envelope ballot came from, but you keep all of that and you record it, and it's done right there at the meeting. And so I'm going very quickly through some really tedious stuff that happens at the meeting. But if you have not gone through that process, or you're not going through that process at your meeting, the integrity of the balloting and the results of the balloting could become an issue down the road. So I want to, talk to us, work through Diane. We will consult with you wherever we need to do to get everyone an opportunity to understand how it should work. And if we can participate and help you out in any way, we obviously like that as well. And then last thing I would say is, if you engage an attorney, if you have any questions, the statute and the documents are why you do what you do. I always find it's most comfortable when someone asks the association, the board, or myself, why does the association do this? Or why are they doing that? And the best case scenario for the association is to say, because the documents and or the statute say so. And if you're not doing something or doing something that is in conflict with the statute, or your documents aren't obligating you to do it, and you're just doing it because you feel pressure to do it, or everyone's jumping up and down and screaming, and you say, we're just doing it to placate the association, that's not a good answer. There's exposure there. So we would encourage you to shy away from that, and really stick to what the statute obligates you to do, and it has defined for you, and then what your association documents further set up that are specific to your association. And then, from a membership standpoint, if, I'm not trying to get any board members in trouble, but if your association isn't following a statute, or how the election process is defined, statute or documents, it's incumbent upon the membership to turn it into the state and get it corrected. So with that, I will turn it over to Barbara, because she has a great presentation along with Catherine and Aaron, and I look forward to answering any questions in the Q&A section.
Thank you, Troy, and thank you, Diane. We are so happy to be here with our friends at Southern States Management Group, and we thank all of you for attending tonight. Before I get started, I do want to introduce my colleagues on the call, attorneys Catherine Miller and Aaron Wallet, who practice in the areas of community association law. You guys want to go ahead and chime in and introduce yourselves? Say hi.
Hi, everybody. Hello, happy to be here.
All right, so in the interest of time, let's get moving. Bear with me while I try to make sure my screen's where it needs to be. Okay. There we go. Okay, so we're going to start out with the basics. It's very important to remember that you don't have to conduct an election unless there are more candidates than vacancies. There's no need to put yourself through the hassle and the expense unless you really need to. Your governing documents are going to control the election procedure. However, when they don't, we've got the condo statute and the HOA statute.
Right, and so this is just a pure math issue, right? If you have 5 vacancies coming up and 4 people put in, or 3 people, or even 5 people, you don't have to have an election. If you have the same or fewer number of people put in than vacancies, there's no election. It's just pure math.
Mm-hmm. Yeah. Check your bylaws for eligibility requirements. The Nonprofit Corporation Act specifies that candidates have to be natural persons, age 18 or older, meaning they can't be corporations or other business entities. Eligibility is determined at the time of the deadline for submitting your notice of intent, if you're in a condo, or on the last day that a member can be nominated, if you're in an HOA. A member is ineligible to serve on the board if he or she is delinquent in a payment of any monetary obligation to the association. This is not, there's no time tied to this. This is pure delinquency, right, Catherine? There's no 60-day, no 90-day period that, like the kind you see with suspension of voting rights. A member is also ineligible if they have been convicted of a felony and civil rights have not been restored for at least 5 years as of the date that they seek election to the board. And something I want to note here is that in the past, the division has interpreted civil rights to encompass all civil rights. So if you've been a felon and your voting rights have been restored, but you still can't own a firearm, sorry, you are ineligible. And
that ineligibility, Troy referenced this, is an important thing to check before you send out a ballot with people's names on it. So I had that happen to a condo. In fact, it was sitting board members, I think, that maybe reapplied and had some late fees that they hadn't paid. I don't even know if they knew they had the late fees, but that they had some, they paid untimely their assessments, and they had some late fees and unpaid, and it wasn't checked, and ballots got mailed to everyone. They had an election, board members were seated, and someone made a complaint, and the Division of Condominium made us go back in time and redo the entire election all over again. And so it was just a big expense. So, the ineligibility is serious stuff, even though it was a, $25 late fee. We had to redo the entire election.
I've got a situation now with a client where there was an eligibility issue, a candidate who put in and didn't know that there was some amount that they were in arrears on in their account. And there's some question as to whether the association didn't even make an effort, frankly, to notify and say, hey, received your information about your candidacy. Want to let you know that you have maybe this $25 late fee you didn't know about, or hey, you're behind 6 months in assessment. Did you know that? There was just no real attempt to let the candidate know, and instead there was a big surprise move, when they announced that actually we only have 2 eligible candidates, because and it just sets up a dynamic where I don't think that's what the intent here is, right? It's not to catch someone and not allow someone who's interested because of a situation with their account that they may or may not know about, which is different though. Sometimes, and Barbara and Catherine back me up, sometimes you'll have maybe disgruntled owners, right? That maybe they were assessed a fine and they disagree with it, so they're not going to pay it, but they're also now going to run for the board, to stick it to the man and change things, right? And so one of the things that comes up often in this slide is that phrase, it's assessment, it's fines, it's fees, or any other monetary obligation to the association. So sometimes it comes up where the association sent someone an enforcement letter. They may have paid the assessment or paid the fine, but they weren't going to pay those attorney fees. And that falls under that category of other monetary obligation. And so, different scenarios, but again, just be careful. Like Catherine said, it's real important to check your eligibility before you send out your ballots, but also important to communicate with those candidates who are showing some interest, make sure that they know if there's an issue with their eligibility, so they have an opportunity to cure it.
Mm-hmm. All right, if you're in a condo, a member is ineligible to serve on the board if they were previously removed by the division. Ownership is typically required, but the association cannot mandate that you be a permanent resident of the state of Florida in order to serve on the board. In an HOA, a member can nominate himself or herself as a candidate at the meeting. However, the association is not required to allow the nomination at the meeting if their election procedures provide that nominations should be made before the meeting. Also, write-in nominations are not permitted if there is no election taking place. I've got some tiny statutory language down there. But that's the takeaway. Write-in nominations are not permitted if no election. Term limits. So this applies to the Condo Act. Catherine and Aaron, is there a similar provision in the HOA Act? I deal primarily with condos, but
not currently.
That's okay. Yes, in 2018, the Condo Act was revised to limit board members to 8 consecutive years of service, unless the unit owners approve it, if 2/3 of the unit owners approve it, or there are not enough candidates to fill the vacancies. Currently, the division's position on this statute, although that's not like a binding decision of law, their position is that this only applies to terms that began on or after July 1st, 2018. There's been a lot of confusion as to whether this applies prospectively or retroactively, and that is the position that the division's taking. As far as I know, there's been no cases decided on this statute.
That's right. When it first came out, if you've gone to some of our seminars, you may have heard us say, condo folks, be careful. If you've been on your board for 8 years already, or you're nearing 8 years, you might want to take a year off, because taking a year off will restart your clock. But when the change of governors, Governor Scott's appointee in the Division of Condominium took a different view than Governor DeSantis's appointee. And so right now, the current guidance we have, although again, no court has issued a decision on this, is that so you'll have until 2020, what is that, 2026? Lawyers don't do math, so don't trust your lawyer with math. But but 2026 is now the deadline if you're a condominium.
Okay. All right. Your governing documents are going to provide the specific procedure for your election. Elections are typically held at the annual meeting, but your association can vote to change that. The Condo Act imposes strict notice requirements, and Troy was alluding to those earlier. So in your condo, a first notice of election has to be mailed or delivered to the unit owners 60 days before the election, no less than 60 days. Then, no less than 40 days before the election, interested candidates provide their notice of intent to be a candidate. Again, if there are only enough candidates to fill the positions, if candidates don't exceed the vacant seats, no election is necessary. If you do have more candidates than seats, then at least 35 days before the election, the candidates may submit information sheets to be distributed to the owners. And then between 14 to 34 days before the election, the ballot and those information sheets are to be mailed or delivered to the unit owners with a second notice of the election. The board cannot send any communications which endorse, disapprove, or comment on any candidate. And I want to note here, with those candidate information sheets, the association is not liable for what is in that sheet. It's the candidate who's liable for the information provided.
Yeah, we have clients who's so a couple things about this slide. First of all, again, this is a numbers thing. It's a calendar thing. So I have clients that say, "Can you give me an opinion on the dates?" And I said, "You want to pay me $300 an hour to look at a calendar and calculate backwards from your election?" I can. I'm happy to. But usually you just start with when your election happens, right? This is going to be the date of your annual meeting. And you're going to just count backwards on your calendar and mark those dates on your calendar. And we get a lot of questions about the candidate information sheet. And, someone's used their own form. Someone's put something, vote for me and my two buddies. We're kind of a group running for office. Vote for me because I have XYZ credentials and, it's not certain if they have them. Just don't edit their document in any way, except that it can be double-sided. You can put candidate A on the front and candidate B on the back, but just replicate what they've provided. And the board can't send any communication. So it gets really tricky. If the outgoing president says, "Oh, please, I really like such and such, hope they get elected." How do you do that? And certainly would advise against that. But if it's something someone feels compelled to do, they better be doing it in their personal capacity and not sending it out on any formal association emails or using their prez@condo, at gmail.com. I don't want to see that.
Proxies are not permitted for board elections. Election must be by secret ballot. And in a condo, this is done by using, the double envelope system. Florida law requires that the sign-in sheets, the ballots, voting proxies, all other papers related to elections must be kept by the association for at least 1 year. And I realize now I probably made this confusing by putting proxies in that last paragraph. But again, proxies not permitted for board elections.
And
In
honestly,
condos.
it's super important that retaining all of those records, right? Because correct me if I'm wrong, I think a challenge to the election can be brought within 60 days after the election. So, just because it seems like the election went pretty smooth and everybody's happy with the results, and you think, hey, we don't really have the space for this, and so if all of those records or some of them get thrown into the trash, and then here you go on day 55, and we've got a challenge, and if that challenge goes to the division, they're going to ask for those documents, and that's could be proof and things of that nature. So it's important to keep those documents.
Mhm. So. Eligibility of voters. Let's talk about that. So check your governing documents for eligibility requirements. You've probably noticed a theme that you need to check your governing documents whenever you're looking at an election. In general, every unit owner is entitled to vote. That's a right pertinent to your membership in the association. However, an owner is ineligible if voting rights have been suspended for non-payment of a monetary obligation. And that contemplates that the association has followed the proper procedure for suspending voting rights, or the unit owner has delegated his or her partial vote to a joint unit owner by executing a voting certificate. So the ballots must list all eligible candidates in alphabetical order by surname. They must not indicate incumbents. It cannot contain write-in candidates. There must not have a space or must not be a space for voter signature, because again, this is a secret ballot, and all ballots must be uniform in color and appearance. The association must provide to the voters 2 envelopes, one outer envelope that is pre-addressed to the voter. The envelope is going to contain a place for the name of the voter, unit identification, and the voter's signature. The association will also provide an inner envelope and, of course, the ballot. Once received by the association, no ballot may be rescinded or changed. As Troy mentioned at the beginning of this presentation, ballots are not to be opened until the election meeting. Electronic voting. I am going to pass this to Catherine right now because she has more knowledge on this topic than me.
Well, I have a number of clients who have asked about it. So, in complete candor, I don't have any clients that I know that are doing electronic voting, but because of coronavirus, and I think that's sort of the thing, right? We're all being flexible this year and trying to be electronic where possible. And maybe we're not wanting to touch things, or be gathered in the same space. Can we do electronic voting? And the 2 envelope system is required for condos. It's not required for HOAs, but if you're in an HOA and you're a few documents provided, I love this. In years where it's okay to gather in person and we have no concerns about the mail, it's a really great, trustworthy system. And so I've encouraged a number of my HOA clients, if you're permitted to do secret ballots or required to do secret ballots, to do the double envelope system that's required for condos. If you're in an HOA and you don't have a requirement of a secret ballot, you can do a proxy in an HOA, unlike a condo, right? Condos, no proxies. An HOA can have a proxy ballot for voting. And I have had HOAs turn those in a variety of ways, right? Where if it's not a requirement for a secret ballot for voting, could you accept a fax? Could you accept turned in a different way? And my answer has been yes. But there is a specific provision for electronic voting in both condos and HOA statutes, and it requires an internet-based or online system. The board has to pass a resolution and the board has to give 14 days notice. So this year I've had clients say, tomorrow's our board meeting, and I had a couple board members bring up to me that they'd like to do voting, on email or voting on SurveyMonkey or voting on, and that's not what this is, right? This is something much more formal. And so the board would take it up with a resolution, and they would give owners 14 days out ahead of time from that board meeting and say, we're going to vote on a resolution to allow electronic voting. And then after that, you're going to be sending out notices of election. So it's probably too late for most of you. If you're having an end of the year election, you're going to be too late for electronic voting for this year. But something to consider if you've been asked about it, I think the board should take it up in the spring or summer of next year. And maybe that's kind of a judgment call to see how we're going with this pandemic thing and see what the drive is to get. I mean, I think some things are just going to stay. I think some people like more Zoom meetings and, easier when you're traveling around the country or out of the area. Maybe people will be more scattered and they'll like electronic voting instead of envelopes or save on the mail. And I have a couple of names of companies. There are a couple that have done this for years and years. A couple that are independent from other groups that just do voting, that do it for HOAs and condos, but also do it for other industry associations, bar associations. The Florida Bar, when we elect our bar president, the 100,000 lawyers of Florida have the option for electronic voting now. So these systems have been around for a while. And I know that, for example, Becker and Poliakoff, the law firm, I think they have in-house proprietary electronic voting. They or I don't know if it's in-house, but related to Becker and Poliakoff that they use. And so after the board elects to offer it, then an owner has to consent to use it. They consent in writing, and electronic is good enough in writing, but you have to have some record of the person saying, I choose it. And if they don't choose it, they still get to paper vote. And once they've opted into electronic voting, this is a question I've gotten, do they have to re-opt in every time? My impression is no, that once if the board wants to stick with electronic voting from then on out, and the person has opted into electronic voting, they can opt out at any time, but they're sort of stuck in while they're in. And so again, something to consider going forward. We had a lot of questions about it this year, and it's there's the statute and there's also a Florida administrative code about it. So, but it acts the same as the double envelope or the paper ballot.
But like you said, Catherine, I think that a lot of our clients and a lot of the questions we were getting were not realizing that it's a more formal process. Most of the questions we were getting and fielding from clients was, maybe we don't have time for the ballots or what have you, and just as a convenience, or hey, are we still technically under an emergency? So can everybody just send in their email with their vote? And obviously the answer to that is no. And so that's I think where we were getting a lot of the questions regarding electronic voting, that's not the statute, and the procedure that's provided is a more formal procedure and not intended for email voting.
Yeah, it's going to be more, I agree completely. It's going to be more formal, and it's going to be, at least initially, more expensive unless everyone opts in and you're saving everyone's mail costs. It's going to be more expensive to pay a company to do this for you.
All right. Thank you, guys.
I just want to jump in here. Thank you guys so much. We're at 6:15 and we want to keep it to an hour. And I know we've got a lot of slides left. So just wanted to give you guys a time check. Thanks so much.
Yes, thank you. I was actually looking at that myself. I put a slide in here for voting machines. Catherine, Aaron, do any of your clients use voting machines? Truthfully, I've never run into an association that does, but here you go. It's allowed. And the Florida Administrative Code has very specific requirements about it. So as far as conducting the election, again, check your bylaws. In a condo, at least 20% of the eligible voters must cast ballots. In an HOA, a quorum is required. Ballots received before the meeting are to be collected and brought to the location of the meeting. Again, don't open them before the meeting. The association should also have additional blank ballots available for those voters who have not yet cast their votes. So this is more about the procedure once the meeting starts. First, you collect the ballots that have not yet been cast. Next, after all the ballots are gathered, an impartial committee checks the signature and the unit identification on the outer envelope against the list of qualified voters. If an envelope is unsigned, it is disregarded. In the presence of the owners, all of the inner envelopes are removed and placed into a receptacle. Once this begins, the polls are considered closed. No more ballots can be accepted. Then the inner envelopes are opened and the ballots are counted. Inner envelopes that contain more than one ballot are disregarded. Those ballots are not counted. All ballots and envelopes, including the disregarded ones, must be retained as official records. With the ballots containing votes for too many candidates are disallowed, but a ballot that contains votes for too few candidates are still counted towards the individuals that person voted for. I just thought that would be an interesting note as far as counting your ballots is concerned. So the impartial committee, this committee is appointed by the board. The committee cannot include current board members, current officers, board candidates, or spouses of those individuals. Election monitoring by the division is available if it is petitioned for by 15% of the total voting interests or 6 unit owners, whichever is greater, at least 14 days before a planned election, and the association bears the cost of election monitoring.
I think maybe in 10 years of really doing condo HOA law, I've had one client that there was petitioning for election monitoring. But we do get asked a number of times if we'll come to elections or if attorneys should be there. And there's no real magic. Some of our clients do. Again, it's whether you want to pay us our hourly rate to come sit there at the meeting. We don't have any attorney magic to make it go more smoothly. And I generally dissuade people. But if you really want us there and there's something we can do or some specific thing you're worried about that we can be ready for ahead of time, then I've gone to some elections. I've been there physically. I think some of the other attorneys at my firm have as well.
All right, so the election is decided by a plurality of ballots. So whoever gets the most votes wins. When you've got a tie, the association must conduct a runoff election for those candidates unless the bylaws provide a different method. The runoff election must be held 21 to 30 days after the date of the original election. Notice of the runoff must be given within 7 days of the original election. Notice will include the date of the runoff and include a ballot and candidate information sheets previously submitted. And before you go through this process of a runoff election, go back and check your ballots. Make sure that it's actually necessary. Make sure that disregarded ballots were properly ignored. Make sure that the ballots with too many votes or too few votes were treated properly. And do the math again. Just recount and make sure you got it right. A tie vote cannot be resolved by withdrawal of the excess candidates. A candidate can only withdraw before the original ballots are mailed. Additionally, you can't resolve a tie vote by an agreement between the tied candidates. That takes away the membership's right to vote for their directors.
And real quick, I mean, sometimes what I hear from clients is classic, there was a tie, and so the two walked over to the corner and they drew straws, and and it seemed amicable, right? They walked away, they chose, Bill over Sally, and Bill and Sally are fine with it. The problem is, right, your membership has just as much basis to challenge that. So again, within that 60 days after the election, if you have members who are present and who don't agree with what Bill and Sally did, they would certainly be within their rights to challenge that election. So pay heed here to the statutes which say the association must hold a runoff election.
Elections may be challenged. Any challenge to the election must be made within 60 days after the election. That challenge goes to mandatory binding arbitration with the division. And be careful if you are the board that declares ballots or an entire election to be invalid. You've got to be able to demonstrate a legal basis for that determination, or you're risking violation of the Condo Act. Sometimes after an election, you've still got vacancies. Vacancies may be filled by an affirmative vote of the majority of the remaining directors, even if they don't constitute a quorum. They can also be filled by another election, in which case you've got to follow the regular election procedures. If you fail to fill those vacancies sufficient to establish a quorum, your association may be at risk of going into receivership. Any member may apply to a circuit court for appointment of a receiver to manage your association's affairs. You want to avoid this. It's extremely expensive. Please, please, please make sure you can find those members who are willing to serve on the board so you can avoid receivership.
Right, and so combining the last slide and this slide, you can get down to one board member. You can be down to your last board member, and they can appoint people up to a quorum, and then you're safe from receivership. But we want to make sure that there's a quorum on the board. And I've received a question about, well, we have a vacancy on the board now. Is that a problem? No, I mean, ideally your board would be full, and then you won't have problems meeting quorum, but if you're down a person, you can go the remainder of the year down a person or two. That's okay. And I also had a question about, does a HOA board have to do the call for candidates? Well, you really should, but some HOAs do have elections, nominations from the floor. And so for an HOA, again, you check your specific documents, but there may be voting from the floor on the night of the election. And again, so then if you wind up still with vacancies, the new board gets to fill those seats.
And I think from a practical standpoint, I've seen associations who have that vacancy, whether it's in the middle of the year or after the annual meeting. Correct me if I'm wrong, but associations are asking the question, all right, let's just send an e-blast out and see if anyone else wants to run for the board. And so I was told a while back, if you're going to call for candidates, which is basically what an e-blast is, you need to follow that election process to the T. So just identifying someone on your bench, someone who's kind of waiting to step up into a role, and just having a duly noticed board meeting and appointing them on motion second. I appoint Sally Smith to fill the vacant seat. And then move forward that way. Sending an e-blast or, and some type of notice in a newsletter or something is a call for candidates and should be avoided unless you're going to go through that formal procedure.
Absolutely.
If I have a clear opinion on whether the e-blast obligates you to have an election, but if you're, if you get a whole list of candidates and the board decides, you're going to have a lot of owners complaining that they weren't chosen. I know that there's some concern like, oh, well, you just picked your buddy. Well, we had a vacant seat and the board is allowed to fill that. So use that easier, less expensive, go grab someone, who's friendly and easy to work with and get them on the board.
I'm going to gloss right over this slide and we're going to stay on vacancies. The last slide was just about certification after a board member is elected, but we're focusing on election process here. So I will move right into this. The 3 ways midterm vacancies arise are removal, resignation, and recall. Removal, a director may be removed by the board for certain offenses, the 90 days delinquency in monetary obligations, charges of the specific crimes you see right here, forging ballot envelopes or voting certificates, or destruction or refusal to allow inspection or copying of an official record if that's in furtherance of a crime. Vacancy caused by removal shall be filled in accordance with election procedure. Removal may also happen as a result of changed circumstances. If your documents require that board members must be members of the association, and a board member sells their unit and is no longer a member, then of course they are no longer eligible to serve on the board. Directors may also resign at any time by delivering written notice to the board, its chairperson, or the association. It's effective upon delivery of the notice unless otherwise specified, and acceptance of the board is not required. So when you've got vacancies that are not the result of recall, which we will address later, the procedure should be specified in the governing documents. You don't necessarily have to have a membership election to fill that vacancy. They can be filled by affirmative vote of a majority of the remaining directors, the sole remaining director, or a membership election. Let's see. Unless the documents provide otherwise, a board member who is appointed to fill a vacancy fills out or serves the remainder of the unexpired term. A new term does not begin. The eligibility requirements we've discussed previously still apply. A non-recall vacancy may not be filled by a director who was previously recalled during the last election cycle. So they're not going to sneak back on the board this way.
And I'm just going to jump right in really quick. I know that we are coming right up at the end, but I know that we have some amazing slides left. So just hang in there with us, you guys. Just a lot of great content, and we're getting through it as fast as possible. So thank you for staying with us.
Yes, thank you. Thank you so much. Recall. Here are the, there's statutes and administrative code that govern recall. Let's see, board members may be recalled by a majority of the voting interests at any time, with or without cause. There are two ways to do this. You can do it by written agreement, which is the division's recommended approach, or by a special meeting. It's much harder to satisfy the requirements associated with a special meeting than it is to comply with the written agreement procedures. So that's why the division recommends it. Substantial compliance is required. Consult counsel to ensure compliance with a recall. With a recall by written agreement, basically you get a collection of ballots from owners voting on whether to recall the current board members. You serve that agreement on the board. And I've used written agreement and ballots interchangeably here, but written agreement basically means the collection of ballots. Then the board holds a special meeting to certify or reject that recall effort within 5 business days of receiving that agreement. By special meeting, regardless of what your documents say, a special meeting can be called for a recall by 10% or more of the voting interests. The owners start this by signing a signature list. They deliver this signature list and notice of the special meeting to all owners and to the board. The board is then obligated to conduct a special meeting is then conducted. If the members vote in favor of the recall, the board then has to notice and conduct a special meeting within 5 days after the recall meeting. At that board meeting, the board votes whether to approve, or the term we use is certify, the recall, or they vote to dispute it. If the recall is certified, the recalled member or members are removed from office, and they must turn in all association records or other documents in their possession within 10 days of the vote to recall. So that would be within 5 days after the board meeting. If recall is disputed, the board files a petition for arbitration, and that petition must be received, not just mailed, no later than 5 days after that board meeting is adjourned. So there's a very narrow window for you to get that petition sent to the division. If the recall is certified, then the recalled board member may file a petition to challenge the recall within 60 days after the vote. If the board fails to hold the meeting, or if the recall is rejected, then the unit owner representative who spearheaded the recall can file a petition for arbitration. And that petition must be filed within 60 days after the expiration of that 5-day period following the recall vote. Let's see. Keep in mind that the division is not going to accept a recall petition when there are 60 or fewer days until the scheduled re-election of a member that's being recalled, or when fewer than 60 days have elapsed since that person's election. Okay, so we're in the era of COVID-19. We're social distancing. We're conducting virtual elections. We're using electronic voting. I know this is a hot topic for a lot of associations. And I'm going to call on Catherine and Aaron now to offer their thoughts about, how do you conduct an effective election during this pandemic? We've talked about some ways. What are your clients doing? What are you seeing?
Well, I think as we talked about, I'm not seeing any of my clients undertaking the formal electronic voting procedures, but many of my clients are getting organized maybe a little bit earlier than they would have in other years past, because there is maybe a concerted effort to encourage owners to vote by ballot. There's also a lot of efforts being taken to, where in years past, right, there wouldn't have been efforts to make the annual meeting visible through like a Zoom call like we're doing now, or through a conference call, making those options available. So of course, to the extent that you can, if you can have your meeting outdoors, you have that ability. Certainly social distance. You want to be able to try to the extent that you can to still hold a physical annual meeting. You have that obligation in your documents. If your documents say that it has to be on the third Saturday of December, then that's when you have to have it. And if you have some flexibility in your documents, try to use that flexibility and hold off, in the hopes that obviously the cases go down and things improve. So maybe it will be a little bit safer, let's say in January, February. So if your documents allow, you can hold your meeting anytime within the first quarter of the calendar year, great. Let's hold off and wait until the end of February and just push it back as long as we can. But I'm highly encouraging my clients to start taking efforts now to make available every possible option for their owners to attend remotely. So Catherine, do you have anything in addition to that?
No, I think I would agree with that. And just, what we're all experiencing, whether it's in our families or our HOAs or our workplaces, or everyone has a different level of comfort. So some people are not leaving their house, end of story. They'll send you a envelope back and maybe they'll Zoom in, but they're not leaving. Other people are out and about and with a mask or without a mask. And so you got to kind of figure out what is the safe thing. Obviously, social distancing and masking is a generally accepted, safe way to proceed. And that's how we would encourage it. And that's the sort of the outdoor I have people who traditionally would kind of rent a small room and maybe now they're renting a large space or trying to find a large space so they can spread out or to shorten the meeting. So no one's inside for a particularly long amount of time. So, we're just trying to make it work, and it's a really new era. We have not experienced anything like this before. And I just think it's really important to be accessible. And I think I'm seeing a slightly lowered interest in new board members this year. and I don't know if that's Troy's experience, but associations not having elections or not having the interest to fill the seats. And so we're fielding some of those questions of, we only had one person put in for next year's board or two people put in for next year's board. And just to remember that the work of the association, y'all know it, is still going on. And so to recruit people and to tell them it's not some onerous thing to be on your association's board, but really a privilege to get to work and make the community better. And
And
just make that easy.
I'll jump in real quick. What we've seen, we had a couple elections happen over the summer. One of the associations, because everything was so new, they actually sought a position statement or a resolution, I think is how they put it in play. And they sent that out with the notice on how they were going to conduct the election. And it actually involved the ballots being opened by management. And so the Zoom thing was just starting, and they, people were allowed to kind of zoom in and watch it. And so we've seen a very different hybrid, not different, but a hybrid of that, where we're trying to, or as you said, organize early, and they're either doing it outside at their pool or out in a much larger room that they ever had intended, and then giving people or originally used, and then giving people the option to participate remotely, and just putting a camera on, letting those who are there trying to identify volunteers that will open the ballots and just let everyone watch it. And so if it's ever challenged down the road, number one, the resolution, the thought process of that council was, we told you in advance how we're going to do this. It's new to everyone, and we're going to back it. And so that was one of the trends that we see. But I think the blend of those who want to come, those who want to participate remotely, have that option available, and then no one will feel disenfranchised.
Just be real careful. I mean, this week I've had association contact me and say, well, it's an emergency, right? COVID, we're just not going to have an annual meeting. It's not safe. And isn't there more, and they started kind of going down that road, and I had to really caution them and say, your documents, one, I would caution to say, we're not under a declared state of emergency now, certainly in the same respect that we were right in March and in April and things. So things have opened up, certainly Florida in particular, so with that in mind, I think there's more, frankly, a little bit more liability potentially from claims from owners if you just say, we're just not going to have an annual meeting. The business of the association has to go on. Your documents say you shall have an annual meeting. Your owners are entitled to obviously attend and get financial information and operations information. So just trying to sort of rely upon COVID as a reason why we're not going to have a meeting this year, even if you're not having an election, right? You take the election out of it, but hey, we're not having elections. We don't have a lot to report. We'll just email everybody the budget and we'll call it 2020. I think that's dangerous. And so there are options where you can have the meeting, keep everybody safe, allow participation. And I think the association really has to explore those.
And one more real quick point, we're seeing a lot of associations send their first notice with a to be determined location and or electronic format, and then formalizing that in the second notice. Right or wrong, it's sticking, and we're just keeping them informed along the way, because 60 days plus out, state of emergency, whether it's on or off, could change within that time frame.
Yes, so I mean, certainly the COVID numbers change all the time, right? So I was doing more, and now I'm like, I don't know if I want to go to all those places, just personal preference. And so your homeowners are doing that same thing. And so I don't mind. My suggestion would be to list a location and say something like subject to change, or we'll also send out online information. The more you can nail down, the better, but certainly give yourself some TBD wiggle room about, it may change, and your venue may change. Your venue may not allow you to bring 50 people into the building anymore. We did receive a question about whether someone Zooming in could count towards quorum to hold the meeting. You're going to hate this answer. I think it's going to depend on your documents, right? And if your documents say something about in person or present, I have some concerns about that. But you could do a proxy to get the attendance, have them mail in a proxy piece of paper and let anyone Zoom, if that were a concern. Or depending on what your individual documents say, maybe the Zoom is good enough. I think it's going to be a individual specific assessment for each association as to whether you could count someone Zooming in as attending, but I don't think you can really vote by Zoom.
There we go. So we're at Q&A. We've answered some Qs. Do you want me to stop sharing my screen, Diane?
I would
Because
love
I know
for
we
you-
are.
I would love for you to put up the last screen so everyone can
Oh,
see
yes.
contact information.
There we go. Brooks was not here tonight, but he's on our slide. So this is where you can contact us. Feel free to email us, reach out, give us a call. We'd be happy to talk to you about your association's concerns. Thank you so much for being here tonight.
We do have one that just came in to follow up on that question. We have sent in proxies to establish a quorum. What happens though if we do not get a quorum in these proxies?
So I'm assuming this is a HOA, and an HOA that doesn't get quorum technically doesn't have the business of the annual meeting, which would include the election, right? So I've had associations try and not be able to get quorum. So they technically don't have a meeting, they don't have an election. And again, it's going to depend on your individual documents, what they say. But usually if there's no election, the old board continues to serve. A number of them will probably resign or drop off because if they didn't sign up to come back. But so, I encourage people to work hard to make a quorum. So whether, you need to make a few phone calls or follow up with people or send out some email blasts, please send back your proxies so we can get a quorum. And some people do proxies without any other business other than to get a quorum. So I have seen a number of those proxies only for the purposes of quorum. And sometimes there's something else to vote on too, but I would really push the proxies. And if looks like it's not going to work, check your specific documents to see. But generally, you don't have a quorum, you don't have the business part of the meeting.
I also just got a recommendation from a board member to let you know that if you're having an outside meeting, outside of a building, to ensure the irrigation system is off. And I think that's a good suggestion. So thank you for that. One more question that just came in. Can proxies be emailed?
Depends on if you're a condo or HOA. So, and I have had, maybe it doesn't. I know I've written them for HOAs where they have been accepted via email. So, you're allowed to return them in whatever format, right? The proxy is not secret. There's nothing secret about a proxy. So I have had some say you can fax them back. You can email back to this address, and maybe that would be the same for a condo proxy. But again, you can't use a proxy to do an election in a condo. Mm-hmm. So to get a quorum, you could say, email me back the proxy form.
I think the statute just says it has to be received by the association prior to the start of the meeting. I'm not sure that it gives real specific details on how it.
But again, a proxy is not, people think of maybe less formal, I give Sally my proxy, she can vote for me. That's not what a condo or HOA proxy is. It's a very specific form that you've filled out, you've checked what it's good for, you've signed it as the voting representative of your home or your unit. So there's a form that has to be used. So you can't just email in, hey, count me there for the meeting, or I give my proxy to Susie. That's not good enough in the condo HOA context. But I think you could, if the board made the decision to accept paper proxies, scanned in and emailed, absolutely. Troy, you see any problem? Is Troy still there? Do you see any problem with that?
Yeah, no, it's an advanced procedural, as long as it's not in conflict with the documents or the statute. It's just the association. We're always an advocate of, be proactive, get the stuff, get the, channel the opportunity for them to participate and make it as easy as possible and make it available to everyone. And, I think at the end of the day, it's, you can't be, as long as you're not in conflict with statute or the documents, I don't think you can be criticized or there's exposure there. I got a question about the statute speaking to the election process, and I think one of the first or second slides, Barbara, you had that up there. So that was one of the questions that I got earlier. So that was the only thing that I had that was open from a question standpoint.
Well, I had a question earlier about how does the board check for felonies? Do we just need to update our forms? And it's really, I guess, for just Aaron and Catherine to help with that. Do you just want us to update our forms and just say by signing this, your signature lets us know that you're 18 and older and that you haven't committed a felony? Would that work?
Yeah, that's a good question. I think if you do your form like that and have your candidates basically attest to that, and short of running criminal checks on everyone, which is not a great idea.
Right.
I tend to think that is a good way to go about it.
Okay.
Yeah, usually there's some level of suspicion. That the only times it's come up have been like, well, we think so-and-so has a criminal record, or we're concerned about such, and we checked. I've never had it just done for every candidate, but I do strongly recommend checking to see that every get with your treasurer, get with the management company and say, is everyone caught up on their payments? Does anyone owe money?
Yeah.
Put them on the ballot. Because that's more, to my mind, that's more likely to occur than someone with a felony. But let people know that that they're not eligible. Like let people know the baseline for eligibility, and whether your state has any. We get the question all the time about, well, they don't actually live here. It's someone's daughter, it's someone's son, or it's someone, and don't they have to be an owner? Not in every association. So you do want to make sure the board and the applicants are familiar with the eligibility requirements.
I have two more questions that have come in, and for anyone that wants to pop off, we so thank you for allowing us to go over. We only were a few over, and we thank you for that. And attorneys, if you're okay with just taking two more, we'd appreciate it so much. The first one is, can a non-owner who resides in HOA home be eligible to be on the board?
Probably.
It depends on what your documents say.
Okay.
I mean, if there's no, my understanding is if there's no requirement that you be a member to serve on the board in your documents, then that person could serve on the board.
There's no statutory, by statute, it's not required in either condo or HOA. Most HOA governing documents say be an owner. Most HOA documents do not say that, but if you do, or have some other eligibility, some HOAs, the board is comprised of representatives from sub-associations or something. So again, you want to kind of look at how you're comprised. And the reasoning is, especially for smaller HOAs, you may want to get someone with a specialized area of expertise. You may want to have an accountant on the board, or someone from down the street, or a lawyer on the board, or something. It may be hard just to get 5 people on the board if you've got an HOA of 20. With Troy's almost 2,000 member HOA, they probably have less of a hard time filling seats.
Yeah, so reference documents is best. Yes. Yes. And then the next question that came in is, when nominations are taken from the floor, no previous disclosure checking for eligibility can occur. What do you suggest? And that'll be our final question.
That's the danger with on the floor. Anytime I see those in documents, I just cringe. I think, nominations from the floor are wrought with potential issues. in all manner, right? How it's going to be handled, and whether they're eligible. So I don't have a straightforward answer for you because I just think that process creates far more problems than it solves. But it would be hard, right? I mean, you have to have your secretary there with your owner role, so to speak, just to be ready for it, and I don't think you'd obviously be able to check for felonies and those types of things, and whether someone has been suspended by the division, those types of things. But at least you would be able to check real quick, if someone is current in their obligations to the association, and you'd have to check the other things after.
Mhm.
Well, thank you to Troy Railsback with Southern States Management Group and all of you wonderful educated attorneys at Wright and Casey. All of their contact information is up there, but as always, you can find more information about them at surfcoastlaw.com, which I think is so cool. Our presentations are always available on the Southern States Management Group's YouTube channel. We also have some great resources on our website, and under the news tab, you can find this presentation and you can share it with other board members who may not have been able to attend. But really, we encourage you to have your board members attend these live so that they hear the information for themselves. Watching a video is great, but the interaction is very important. And because of the times, we appreciate your time in listening and being a part of it. And there was some appreciation from some members. And so thank you to everyone for attending and for going over a little bit. We hope that everyone has a great night, unless Troy or any of the ladies have anything to add.
Thank you to everyone. I really appreciate everyone participating and listening. And Wright and Casey, as always, we appreciate you partnering in our education series.
Thank you.
Good
Everyone
night,
have a good
everyone.
evening.